Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and your mind. You just never use it.
All present. Session 1 of the Walker-Moot Supreme Court in the Ladner Slot courtroom is now in session. We would like to acknowledge that we are speaking to you today from the traditional unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin peoples and all Indigenous peoples in the region of Ottawa who call the nation capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present Justice David Boivin from Gowling WLG, Justice Michael Frale from Foglers, Justice Pinta McGuire from TYR LLP, and Justice Dr. Brenda O'Connor from the UHN. On October 19th, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health 13 hours after her transfer from the West Valley Memorial Hospital. Ms. Stark's medical records reveal she was in perfect health and had no previous existing medical conditions, nor any prior family history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5th, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But the same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Ms. Stark immediately requested Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6th, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and a BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone and pure oxygen. On October 7th, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutsier, chose to withhold any further administration after being informed of Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Ms. Stark's condition worsened, and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutsier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to Math Plus protocol. In response, Dr. Lutsier asked Dr. Strange to forward him the relevant literature for which she was relying on so that he could make a rational and educated decision, which was provided immediately after. Dr. Lutsier determined his time would be better spent attending to patients than reading to what he referred to as propaganda. On October 10th, ICU nurse Dolores Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the Frontline COVID-19 Critical Care Alliance Math Plus protocol. Nurse Patel spoke with attending physician Dr. Andy Park and convinced him to undertake Dr. Strange's request. Within 15 hours, Miss Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Miss Stark's condition had improved, at this point only to have relying on a nasal cannula. On the morning of October 13th, Miss Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Miss Stark was making great progress. However, Dr. Lutsier once again assumed care of Miss Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutsier then administered remdesivir to Miss Stark. Nurse Patel phoned Miss Stark's family and informed them that Dr. Lutsier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Miss Stark's oxygen level began to drop, and she became unstable. Within 3 hours, Miss Stark was placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocols in place. Miss Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutsier, but after 4 unsuccessful phone attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Miss Stark and was unable to speak with Dr. Lutsier. Within 6 hours, Miss Stark's chances of survival had dropped to 20%, and Dr. Lutsier informed Miss Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Miss Stark. Mr. Stark pleaded with Dr. Lutsier to administer the Math Plus protocol and offered to sign a release, releasing Dr. Lutsier and the hospital and any of its agents and parties acting on its behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Lutsier refused to administer Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19th, Dr. Lutsier agreed to the transfer of Miss Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Miss Stark died. In this matter, the questions at issue are as follows. Issue A, the standard of care. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? Did Dr. Lutsier breach that standard of care in failing to investigate the literature he was provided with and denying Miss Stark treatment with Math Plus or ivermectin alone? Issue B, causation. Did Dr. Lutsier's conduct cause or contribute to the harm or injury Miss Stark sustained? And issue C, vicarious liability. Is the hospital vicariously liable for Dr. Lutsier's actions? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Alexandra Robbins and Owen Guinn, and speaking on behalf of the defendant, Dr. Lutsier and the West Valley Memorial Hospital, Nicole Davidson and Manit Kahlon. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutsier, and the West Valley Memorial Hospital. Both the plaintiff and defendant's counsel will have 30 minutes each in total, 15 minutes each council member to present their arguments to this court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they so choose. I will signal to the court via chat when there is 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Thank you. Good morning, justices. My name is Alexandra Robbins, counsel for the plaintiff, and I'm joined by my partner, Owen Guinn. We ask that the court hold the defendants, Dr. Justin Lutsier and West Valley Memorial Hospital, jointly liable for Ms. Kyla Stark's death. The plaintiff seeks $25.34 million in damages. We have 3 primary submissions to make before the court today. First, I will submit that Dr. Lutsier breached the requisite standard of care while treating Ms. Stark. Second, my co-counsel will submit that by failing to exercise reasonable care, Dr. Lutsier caused Ms. Stark's death. And third, he will submit that as Dr. Lutzier's employer, West Valley is vicariously liable for Ms. Stark's death. There are multiple elements of negligence at common law. Some of them are uncontested here, so I'll address them just very briefly. With regards to duty of care, it's been widely recognized in the jurisprudence that where relationships involve supervision and control, and this includes doctor-patient, a duty of care is presumed. Second, with regards to damages, since bodily harm is generally sufficient to establish that damage has occurred, death is more than sufficient. Turning to the first contested issue before the court, which is standard of care. We are in agreement with our friends that for medical negligence, the standard is that of a reasonable physician in the defendant doctor's circumstances. And more specifically, since in this case, Dr. Lutzier is a specialist in pulmonary and critical care medicine, the requisite standard of care would be that of a specialist in his circumstances. The issue before the court today is what this entails. What would a reasonable specialist have done in Dr. Lutzier's circumstances? Now, to be clear, we agree with the defendants that supportive care is a customary practice in the medical profession for treating COVID-19. It's adopted by the hospital, among other health organizations. We don't dispute that. We also agree with the defendants that typically adherence to customary practices will absolve a physician of liability, and this was noted in Terneuzen and Korn. However, the plaintiff submits that customary treatments are not always sufficient to establish a standard of care. Physicians do much more than provide treatments, and this is especially true in unique circumstances such as the COVID-19 pandemic. It's for this reason that there have been found to be breaches of standard of care where, for example, a physician fails to consult a patient's medical history. Standard of care, therefore, goes beyond mere treatment alone. Now, one might look to a few places for a more holistic picture of standard of care. One of these is expert testimony, which we'll refer to later in our submissions. And the second is the practice guide that's laid out by the College of Physicians and Surgeons of Ontario. In referring to these, we submit that there was a twofold breach of the standard of care. And at this point, I'm at paragraph 19 in the plaintiff's factum. First, we submit that there was a breach of the standard of care with regards to failing to read the materials sent to Dr. Lutzier by Dr. Strange. She had contacted him regarding ivermectin use, and he actually asked for those materials to be sent to him. Yet when they were sent, he didn't review them. Our friends submit in their factum that since Dr. Lutzier had sufficient evidence to refute that there wasn't a breach, and they pull from Dr. Moriarty's examination to support this. Now, the issue here is that we would submit that he did not have the evidence to refute, given that he asked Dr. Strange for the literature he was relying on. We would submit that in asking her for this literature, he was recognizing the evolving nature of COVID-19 research, which he also notes at paragraph 12 in his cross-examination. So we would submit in changing times such as these, where research is constantly evolving, there is never a point where a physician can become stagnant and say that they have all the research they need, which is precisely why he asked Dr. Strange, what literature are you relying on for this new conclusion?
Counsel, isn't it sufficient for the doctor simply to follow the hospital's protocols in place at the time? Isn't that the end of the story here?
Justice Fraley, absolutely not. Unfortunately, or not unfortunately, but doctors do much more than simply provide treatments. So it's for this reason that we have a practice guide that gives a more holistic picture of what we expect from physicians. We expect duties from them, such as collaboration, a duty to learn, and all of these go beyond mere treatment. So it's very true that generally customary or following customary treatments gives rise to a presumption of standard practice or a presumption against negligence. That presumption can be rebutted, and we submit that it's rebutted in this case based on the other duties that he didn't adhere to. So the first of these is to collaborate with other healthcare professionals, and this includes the exchange of information and shared decision-making. Here, Dr. Lutzier did not exchange information. He did not engage in shared decision-making. He did not collaborate with the primary care physician who prescribed ivermectin.
Counsel, though, didn't Dr. Lutzier, in his capacity as, medical director, consult with other healthcare practitioners to determine these guidelines? So wasn't he fulfilling his obligation to consult with other healthcare practitioners?
Absolutely, Justice McGuire. Well, he did consult with other healthcare professionals in creating the guidelines to begin with. The negligence analysis is patient focused. So in the context of treating this patient, did he act negligently or did he not? So we would submit that, again, it's not just the duty of collaboration. We'll be supporting it with additional evidence as well. But this is one piece where in the context of working with this patient, he didn't collaborate with one of the most critical members on that team, which was the primary care physician who prescribed ivermectin to begin with. Second, there's also a duty to learn, and this includes seeking out new evidence and knowledge, keeping abreast of current developments. There's a similar duty called demonstrating professional competence, which includes demonstrating a sense of inquiry. So while we recognize that Dr. Lutzier does engage in research on a regular basis, and he created these protocols, here there was an absolutely critical need to read the research sent to him by Dr. Strange, because she approached him, explained that there was a potentially novel treatment option for his patient that was potentially life-saving. He actually asked her for the research, suggesting that he was perhaps initially willing to have a look at it. And then yet when it wasn't sent, he just took his hands off and didn't engage with that literature. Now, our friends submit at paragraphs 26 and 27 of their factum that there was a reasonable choice made to prioritize the care of his other patients over reading the literature, which he had assessed as biased. Now, they did note as well at paragraph 24 of their factum that Dr. Lutzier takes time monthly to review the literature, or he had been at the time because the science is already evolving. Also, he asked for that literature again to support. So we would submit that there was no real constructive choice here to prioritize one or the other. Dr. Lutzier takes time all the time to read research. So the issue of timing is not really relevant here. Again, we're not suggesting that he has to do the most thorough comb through, but Dr. Strange provided him with meta-analyses which have conclusions and easily readable conclusions to draw from those studies. Now, turning to the expert testimony, which is perhaps even more relevant, we can look at Dr. Lutzier's own statements regarding what he would have done in circumstances such as those that he was in. And at this point, I'm at paragraph 24 in the plaintiff's factum. Dr. Lutzier himself noted that the exchange of research by colleagues is standard practice in the medical field, and even more so during the COVID-19 pandemic. Now, when asked about a situation such as that which had arisen in this case, he claimed that should he be faced with a scenario where a colleague were to send him studies regarding novel treatment options, quote, he would engage in formal discussion with his colleague and then read what they sent him in keeping with his duty as a medical specialist. He claimed that since, quote, it's life-saving or claimed to be, you have to investigate. That would be his duty. And yet, when this actually arose in practice, Dr. Lutzier didn't follow up on these statements. He didn't actually carry this through. We can also look to statements made by Dr. Titchener, a pulmonary and critical care specialist, who also said that in such situations, he would have read the studies. He stated that, quote, you are, as an ICU physician, left with the choice of watching your patient die or sitting down and reading a few studies. Standard of care here is you adapt to the situation, assess the patient, speak with the prescribing physician, do your own diligence, and make a decision. We can also look to Dr. Papadopoulos's actions, who was not called for discovery, but his actions are noted in this agreed statement of facts. He initially refused to administer ivermectin. However, after speaking with the family, he engaged in further research and then eventually complied. This is an example of what would be the requisite standard of care here. So all of this suggests that reading potentially novel or life-saving research, regardless of the ultimate decision, would form a standard of care in the situation that Dr. Lutzier was in. And as such, because he didn't engage with that literature, this was a breach of the standard of care.
So counsel,
Sorry, go ahead, Justice Sullivan.
counsel, do I understand your position to say that the breach of the standard here is not to have considered the literature? It was not a breach of the standard to use a methodology other than the methodology that you advocate for today?
Justice, we would submit that it would require more than simply reading. It would absolutely require consideration, but we're not submitting that Dr. Lutzier's only option was then to proceed to administer Math Plus or ivermectin. So when I get to the second sort of form of the breach, I'll explain that. We submit that he ultimately had the option as well to transfer Ms. Stark to Dr. Strange's care immediately. With regards to the literature itself, it would require, of course, consideration, not just a simple skim. Consideration of the findings.
But it was considering these options, not executing these options.
Absolutely. Considering the options, not necessarily executing them. Absolutely. So second, justices, we submit that there was a breach in either failing to administer Math Plus or ivermectin, or in the alternative, transferring Ms. Stark to Dr. Strange's care promptly when the doctor realized that he would not be administering Math Plus or ivermectin. Again, we are not suggesting that the doctor's only option was to choose a treatment that is not customary or governed by his hospital. So the CPSO outlines another duty, the physician's duty to collaborate with patients and others. Now, this requires practitioners to work with the patient in order to understand their needs, to formulate treatment plans that are optimal for the patient, and to address patient questions and concerns. Now, for an example of this collaboration in action, we would point the justices to the actions of both Dr. Papadopoulos and Nurse Patel, as well as Dr. Andy Park. All of these physicians collaborated with the family and the primary care physician, Dr. Stark, before agreeing to administer Math Plus and ivermectin. This is a display of the collaboration that's being articulated here by the CPSO. Yet in both of these situations, Dr. Lutzier intervened, ceased the administration of these treatments unilaterally without such collaboration. If we turn to the jurisprudence, it's noted by the court that where a physician fails to take into account relevant facts at the time of treatment, that this may fall below the standard of care. And in our factum at paragraph 46, it notes multiple cases that have supported this. In this matter, Dr. Lutzier ignored the fact that Ms. Stark was improving. And my co-counsel will discuss this in slightly more detail with regards to the facts. Moreover, a physician may be considered in breach of the standard of care when they fail to provide a treatment that is of medical benefit to a patient, or that could be of medical benefit. Now, interestingly, the jurisprudence says that medical benefit, it's not a scientific question, it's a legal question. And the legal definition for what is of medical benefit is patient-focused and it's contextual. You look to the patient's circumstances, their condition, their prognosis, and their expected results. So in this matter, just as I had mentioned the fact that he didn't consider, Ms. Stark was improving under these treatments. Her prognosis was good every time they were administered. So we would submit that when we look at this contextually in a patient-focused way, ivermectin or Math Plus was a treatment of medical benefit, and thus he failed to exercise reasonable care by not administering. Now, to address Justice Boyven's question that you'd asked me earlier, it's critical to note that we're not attempting to hold the doctor to a standard of perfection. We agree with the defendants that this is not proper. It's a standard of reasonableness. It's just that holistically, he failed to take reasonable care at multiple stages throughout the treatment process when he had reasonable options available to him. Ultimately, he could have always transferred Ms. Stark to Dr. Strange's care as soon as he realized that there was a breakdown in the patient-physician relationship. Had he decided, I'm not going to read these studies, he could have transferred her at that point, realizing that in keeping with his duty to collaborate, his duty to learn, that the only alternative was to transfer her. Again, even after reading the studies, he could have decided, I'm not going to proceed with ivermectin or Math Plus. I'll transfer her at this point, because again, in keeping with my duty to collaborate, it's clear that the patient's family, the patient's primary care physician are not essentially agreeing with him in that position on ivermectin and Math Plus.
So counsel, am I correct in understanding that it's your submission that the critical care specialist should have transferred care to the family physician to provide ongoing COVID treatment?
Yes, Justice. Well, Dr. Strange is a primary care physician, but she also works in critical care at the hospital at Fallview Health, and she offered to take over care, and eventually she did. It's just that at that point it had been too late, and Ms. Stark died within an hour. And again, the reason for the transfer is not to despair. Thank you. I see my time has elapsed. I'll just briefly conclude. It's not to disparage Dr. Lutzier's credentials at all. We understand that he's a specialist. It's just that, again, treatment goes beyond simply the treatment itself. There's all these extra duties to collaborate and to work with the patient. And here we saw a breakdown of that relationship. And that's why we submit that the alternative was always open to transfer, but he didn't take that choice. So to conclude, Your Honors, we would submit that there was a twofold breach of the standard of care in this case. First, by failing to read the literature provided to him by Dr. Strange at his request, and second, by failing to either administer ivermectin or Math Plus or transfer Ms. Stark promptly to Dr. Strange's care. Barring any further questions, I'll now pass the podium over to my co-counsel and he'll conclude on behalf of the plaintiff. Thank you.
Good morning, Justices. My name is Owen Guinn. I'm here today on behalf of the plaintiff, Mr. Sam Stark, and I will be continuing submissions begun by my co-counsel. To briefly roadmap, I have two submissions for the court today. Firstly, that Dr. Lutzier, through his actions, caused Ms. Stark's death. And secondly, that West Valley Memorial Hospital should be held vicariously liable for the negligence of Dr. Lutzier. For my first submission, causation, and for those of you that are following along, I'm now at paragraph 40 in the plaintiff's factum. The plaintiff must show that on a balance of probabilities, it is only more likely than not that but for the actions and negligence of Dr. Lutzier, Ms. Stark's injuries, and in this case, death, would not have occurred. This is a standard laid out by Clements against Clements, and to which the defendants agree. In order to demonstrate this causation on a balance of probabilities, we first look to the number of studies which show that ivermectin is safe and effective in reducing rates of mortality in patients with COVID-19. And I'm now at paragraph 41 through 43. The first of these studies was a meta-analysis, the one provided by Dr. Strange to Dr. Lutzier at his request. And this meta-analysis contains a review of 78 individual studies. And taken together, these studies show a 44% reduction in mortality in patients with COVID who had been administered with ivermectin versus those who had not, with a high degree of statistical significance. But we understand that this one meta-analysis alone may be partially insufficient to demonstrate causation on a balance of probabilities. So we also look to a number of other studies. Firstly, Cobos Campos et al. Conducted a study and a meta-analysis of 53 other individual studies, which based on 17,500 patients found a similarly high connection between administration of ivermectin and reduced chance of mortality in COVID patients. In fact, the significance of these studies was so high that they calculated the chance that an ineffective drug could yield the same results by coincidence was 1 out of 167 trillion. Of course, I don't need to emphasize how significant this number is in indicating the effectiveness of ivermectin in reducing deaths. We also look finally to Santin et al., which upon reviewing 7 randomized control studies, also noted an interesting phenomenon in Peru, where after a state-sponsored mass administration of ivermectin to the population, COVID deaths dropped 14-fold. And when that program was ended, COVID deaths again increased 13-fold. And the study ruled out other potential confounding variables there. The plaintiffs in these paragraphs also point to a number of other studies which corroborate these findings to a similar degree. However, the plaintiff acknowledges that some of the studies within these meta-analyses are of poor quality with sampling and methodological errors. The defendants will use this to argue that there is no perfect scientific consensus as to the effectiveness of ivermectin in COVID-19. However, the plaintiffs are not limited to solely the use of meta-analyses. We merely use them as an indication to start to give us an idea of the amount of evidence that indicates that there is substantial chance that ivermectin can reduce rates of death in patients with COVID.
Counsel, aren't you then talking about just that, a loss of chance, which is not compensable in Canadian law?
Certainly, Justice McGuire. What we're referring to is, again, the balance of probabilities. We only need to demonstrate that due to the effectiveness of ivermectin and Ms. Stark's individual response to the drug, that it is more likely than not that she would have recovered. If we were only looking to the meta-analyses, then there might be some indication that we were only looking at a loss of chance. But because we have this other option in which we can look to Ms. Stark's individual response to the drug and her strong and immediate recovery in response to ivermectin, it goes to establishing on the balance of probabilities that it's more likely than not that she would have recovered. Because in Ms. Stark's case, on 4 separate occasions, she either improved or declined when ivermectin or Math Plus was administered or then removed. On October 7th, when ivermectin was first given, her condition improved within 11 hours. The next day, when it was removed, she declined so substantially as to have to be placed in a medically induced coma, mechanically ventilated. A couple days later, when Math Plus was first administered, she was able to then be brought out of the coma and relied only on a nasal cannula for supplemental oxygen instead of mechanical ventilation. However, then a few days later, when Math Plus was ended, her condition rapidly deteriorated. Her chances of survival plummeted, and a few days later, she ultimately died.
Counsel, what do you say then about the defendant's submissions that was simply following the typical course of a COVID-19 patient, that these improvements and deteriorations in her status could be expected and are completely coincidental with the withdrawal or administration of medication?
Certainly, Justice McGuire. The defendants point to the source of Georgia Bay Family Health Team that indicate that a patient who might have been feeling better around day 7 may then start to deteriorate again after that. And like you asked, they use that to argue that Ms. Stark's deterioration in condition could actually have been due to the normal progression of COVID-19 rather than the administration and removal of ivermectin. However, that source actually only contains a small mention that patients at that period who have been feeling slightly better could then continue to get worse. It's got very little in common with the extremes of Ms. Stark's improvement and then her drastic deterioration in quality in condition to the point of mechanical ventilation. It goes against a common sense and most direct understanding of COVID-19's progression and Ms. Stark's progression in response to a drug. It is, again, only more likely than not that after 4 separate and direct responses to a drug being administered and then taken away, that drug's true effect is the most likely explanation for it. The normal progression of COVID-19 is simply not consistent with Ms. Stark's change in condition. And there's no indication that that is what a normal patient might expect to undergo. We understand that COVID-19 is a varied disease that affects people differently. However, it is more likely than not, again, that such dramatic and immediate shifts in immediate response to drug administration means that that drug was being effective in how it was treating her symptoms. The defense also points to the FLCCC guidelines, which they say note that delayed Math Plus treatment could cause complications. And they again argue that to your point, that it could have been because of this other delayed Math Plus treatment rather than ivermectin improving. However, were that to be the case, again, we would expect to see upon Math Plus delivery, Ms. Stark's condition would then deteriorate. Instead, we saw the exact opposite. When Math Plus was given and ivermectin before it, Ms. Stark's condition improved. And when they were taken away, her condition deteriorated. This again goes against the common sense understanding of what that probably means. And what it most likely means here was that she was responding to ivermectin. Furthermore, ivermectin itself is a safe drug. 90,000 doses are given a week in the United States, with no indication of adverse effects. And I'm now at paragraph 45 of our factum. All studies that indicate that ivermectin could potentially have adverse effects on patients are based on ivermectin being given at high animal doses, those intended for veterinary and livestock care, rather than safe human concentrations as when prescribed with a doctor, as Dr. Lutzier should have done here. We acknowledge that the studies we provided are not necessarily perfect in every way, but when used in combination with Ms. Stark's individual and direct response to the drug, it's a position of the plaintiff that these things taken together establish that it's more likely than not that Ms. Stark would have survived had ivermectin or Math Plus continued to be administered. My second submission, and I'm now at paragraph 51.
Just before you get, Counsel, before you get to that, your argument here is that had she been administered the treatment you advocate for, she would have survived. But that's not the standard of care argument that you're making. The standard of care argument is that there was a failure to consider what's the causation analysis getting you to her life being saved. Had the defendant considered that alternative treatment?
Certainly, Justice Boyven. Had Dr. Lutzier either given Ms. Stark ivermectin, then she would have been more likely to survive. However, based on my partner's standard of care argument, he also had the option of transferring his patient to Dr. Strange. Dr. Strange would have then administered ivermectin or Math Plus, which would have increased her chances on the balance of probability of ultimately surviving. So it was through Dr. Lutzier's negligence of failing to make an informed decision, then potentially failing to administer the treatment that was required, or then failing to transfer Ms. Stark to a physician who would have administered that treatment that ultimately caused Ms. Stark's death. Going now again to my second submission for the court, vicarious liability. In order to show vicarious liability at common law, we use a Salmon test, the first stage of which is an employee's wrongful conduct must consist of acts authorized by the employer. So the question here is, were Dr. Lutzier's actions authorized by his hospital? Dr. Lutzier was a paid employee of the hospital. The hospital assumed risks for him working there, and all of his actions were made on behalf of the hospital rather than himself. Ultimately, the decisions that he made that we've discussed before were negligent, but they were also authorized and allowed by the hospital. They were granted, and he had the ability to do so because of the position given to him by the hospital. There are policy benefits for findings of vicarious liability. I'm now at paragraph 57 of the factum. These are that vicarious liability findings help to provide adequate remedies and incentivize employers to prevent negligence. In this case, the $25.34 million that the plaintiff is requesting would help be supplanted by the hospital's resources and would further incentivize hospitals to not allow their physicians to act alone, not based on their patients' individual circumstances, and instead make decisions based on their own personal biases. The defendants will only argue that because Dr. Lutzier wasn't himself liable, the hospital should not be vicariously liable. This means that if Dr. Lutzier is found to be liable for his negligence, there's no argument as to why West Valley Memorial Hospital shouldn't then be liable for his negligence as his employer. It is fair that when a hospital employs a physician for their own financial gain, they also assume risk for negligence brought about by that doctor in the commission of his duties to his employer. So therefore, the plaintiff argues that West Valley Memorial Hospital should be held vicariously liable for Dr. Lutzier's negligence. Based on this, the plaintiff asks that Dr. Lutzier be held liable for his negligence in the death of Ms. Stark, West Valley Memorial Hospital be held vicariously liable, and damages be awarded to the plaintiff, Mr. Sam Stark, in the amount of $25.34 million. Barring any further questions, this concludes the submissions of the plaintiff. Thank you.
The court now invites counsel for the defendant to begin.
Thank you. Good morning, Justices. My name is Kahlon, and I'm here today with my co-counsel, Nicole Davidson. We are counsel for the defendants in this matter, Dr. Justin Lutzier and West Valley Memorial Hospital. I will address the requisite standard of care. My co-counsel will then make submissions on causation and vicarious liability. Altogether, our submissions will demonstrate that while this was a very tragic outcome for Kahlon Stark, the court should find that there is no liability for negligence in this case. Especially during a global pandemic, we submit the court should not set a precedent where healthcare heroes fear being accused of negligence for following the accepted standard of care. My submissions have three main points. One, the requisite standard of care for medical negligence in Canada is the standard of the reasonably prudent doctor. Two, Dr. Lutzier did not breach the standard by choosing not to review the literature provided by Dr. Sophia Strange. And three, Dr. Lutzier did not breach the standard by declining to treat Ms. Stark with Math Plus or ivermectin alone. My first point sets out the requisite standard of care as it applies in this case. It is established that the standard of care for doctors is to conduct their practice in accordance with the conduct of a reasonable, prudent, and diligent doctor of the same experience and standing. When a doctor presents themselves as a specialist, they are held to a higher standard than a general practitioner. So in this case, the degree of care, skill, and knowledge required of Dr. Lutzier was that of a similarly situated and experienced pulmonary and critical care specialist. It is crucial to remember that the standard of care does not expect perfection from our doctors. Rather, the standard is one of reasonable care. We submit that the counsel for the plaintiff have not met their burden to prove that there was a breach of the reasonable standard of care. Dr. Lutzier exercised reasonable care in his treatment of Ms. Stark as expected of a reasonably prudent pulmonary and critical care specialist. Moving to my second point, Dr. Lutzier did not breach the standard of care by choosing not to review the provided literature, as he had a good reason to not examine the data, which is the standard of a reasonably prudent and diligent doctor. In fact, Dr. Gahan Moriarty, who has significant experience working in the ICU during the COVID-19 pandemic, stated it would be strange for a doctor to not investigate the provided literature unless the doctor had solid evidence to refute the studies or another good reason to not examine the data. Dr. Lutzier was aware that the evidence in support of ivermectin is lacking and that many leading medical societies, such as the National Institutes of Health, have determined that the studies on ivermectin are insufficient. The main concern is that most of the studies in support of ivermectin are flawed due to significant limitations. Dr. Lutzier was aware of these limitations. Furthermore, Dr. Lutzier has monthly meetings with a team of experts and specialists to review the literature. The very goal of these meetings is to keep their knowledge current by reviewing the latest literature so they can amend the hospital's treatment guidelines as required and on a regular basis. This literature is reviewed as it is published, so the team has the most up-to-date medical knowledge. Based on these facts, it can be concluded that if there was high or even medium quality evidence for ivermectin or Math Plus, Dr. Lutzier would have been aware.
But counsel, how is Dr. Lutzier to know whether these studies were medium or high quality if he didn't even look at them? Isn't the standard that he must at least figure out whether it's something that he should delve into further?
Thank you, Justice. So we submit that because with the interdisciplinary team, Dr. Lutzier was reviewing all high and medium quality literature monthly, that it is reasonable to conclude that if there was any data on ivermectin or Math Plus that was at that threshold, high or medium quality, that it would have been reviewed in those monthly meetings with the team.
But the literature is coming out so quickly and the recommendations are changing so quickly. And he's got to look at it in the context of his particular patient. So, you know, things can change on a month-to-month basis. Why should Dr. Lutzier escape his responsibility, which he admits is that's his responsibility to review medical literature? Why should he escape it in this patient?
Thank you, Justice. As I stated earlier, the standard of care is not a standard of perfection. We submit that Dr. Lutzier cannot be held to a standard of perfection where he must read every study every time it is sent to him. This is simply not possible, especially during busy times such as the COVID-19 pandemic. Does that answer your question?
So you're essentially saying that because he was too busy looking after other patients, it should excuse him from his general responsibility to consult studies that are put to him.
Yes, he does have that responsibility. And we submit that he was keeping up to date on his medical knowledge because he was reviewing that literature monthly. Even though new literature in COVID-19 is constantly evolving, he's setting out that time to review that literature monthly with the hospital's team of experts and specialists. So it's not that he is ignoring this duty, he is doing it on a monthly basis to review that literature. But in this situation, if you were expecting him to review the literature at the moment it is given, every time it is given, it is holding him to a standard of perfection.
Thank you.
I would like to, thank you. I would like to further state that in Lapointe and Hôpital Le Gardeau, the Supreme Court held that doctors should not be liable for mere errors of judgment, which are distinguishable from professional fault. Specifically, errors of judgment are distinguished from acts of carelessness, unskillfulness, or lack of knowledge. At worst, Dr. Letzier's choice to not review the provided literature can be classified as an error of judgment, and that is not sufficient to establish a breach of the standard of care. Dr. Letzier made a reasonable and intelligent decision to prioritize the care of his patients using the hospital's COVID-19 treatment guidelines, which again, I want to reiterate, was established by a team of experts and reviewed monthly. It cannot be said this decision was an act of carelessness or unskillfulness. To conclude my first point, Dr. Letzier's choice to not review the literature provided by Dr. Strange cannot be considered a breach in the standard of care. Moving to my last point, it is generally accepted that doctors will not be found liable for negligence when their actions conform with the respectful and recognized practice of profession. The only exception to this is when it can be established that the common practice itself is negligent. However, this requires obvious risks or dangers associated with the common practice that can be understood by the ordinary person. Dr. Letzier followed a course of treatment known as supportive care when treating Ms. Stark. At the time and to this day, supportive care is recognized by medical science as being the most appropriate treatment for COVID-19. Supportive care is a part of the hospital's COVID-19 treatment guidelines, and it includes drugs such as remdesivir, which is the only drug approved by the FDA to treat COVID-19 in hospitalized adults. Health Canada has also authorized the use of remdesivir as a treatment for COVID-19, and Health Canada only authorizes treatments after a thorough scientific review. Leading societies in medicine and federal health agencies recognize supportive care as the standard of care. This is strong evidence that Dr. Letzier adhered to the reasonably prudent standard instead of trying experimental therapies. Moreover, there are no obvious risks or dangers associated with supportive care to show that the standard itself is negligent. My friends
Also, were there any dangers associated with actually prescribing Math Plus and ivermectin though?
Thank you, Justice. Yes, the research has shown that there is a lack of, the scientific evidence shows that it is lacking and that it doesn't show that there is that, that ivermectin or Math Plus is safe or effective in COVID-19. Also, with the other components of Math Plus, most of them have not been studied in relation to COVID-19, or there is clear evidence against its use. For instance, the National Institutes of Health recommends against the use of nitazoxanide, and it is also stated there is insufficient evidence for the use of vitamin D, fluvoxamine, and zinc in the treatment of COVID-19, and all four of these are components outlined in Math Plus.
Is there a difference between there being insufficient evidence and it being harmful?
Thank you, Justice. That is correct. However, with something as novel as COVID-19, it is appropriate that doctors would not feel comfortable administering a treatment where there is an insufficient evidence, where they're not sure if it could be harmful or beneficial. And when leading health organizations are not recommending that stage and they're rather recommending supportive care, it is appropriate for doctors to feel uncomfortable to change, to move away from the standard that is expected.
I guess just one related question. Is it the standard of care, do you say, for a physician to either follow or not follow what a patient asks for? In other words, patient wants to have ivermectin here. What's the physician's role in saying either, yes, I'm going to give it to you because it's not harmful, or no, I'm not because it's not the standard?
Thank you, Justice. We do recognize that physicians do have a duty to collaborate. However, it's important to recognize that there is a line of collaboration. So this was not a situation where there were 2 approved treatments where Dr. Letzier could collaborate with the patient and their family to determine which treatment they would prefer. No, this was a situation where there was 1 approved treatment that is backed by federal health agencies and another treatment that is clearly not approved or authorized. And so this is a situation where collaboration is not appropriate. And I would also like to state further that Dr. Strange herself received a warning from the College of Physicians and Surgeons of Ontario for treating her COVID-19 patients with ivermectin. Thank you. My friends submit that while Dr. Letzier was not compelled to administer ivermectin or MAF+, it was insufficient for him to retain care of Ms. Stark. In Westwick and Colbert, the court held that the decision to transfer or not transfer a patient is ultimately a doctor's decision. The court also held that a mere transfer would not have guaranteed the patient's survival, as it would depend on different factors, such as treatment and adverse effects. We submit that Dr. Letzier had the right to care for Ms. Stark as her doctor, and that even if Ms. Stark was transferred sooner, it would not have guaranteed her survival. Often in medicine, there are multiple treatment options available, even when we are not dealing with a situation as novel as COVID-19. However, the Supreme Court has held that a doctor will not be found liable for negligence if the treatment provided to a patient corresponds to what is recognized by medical science at the time, even in the face of competing theories. Essentially, courts should not become involved in controversial questions regarding the treatment of preference, which is what we see here today. In light of competing theories regarding the treatment of COVID-19, Dr. Letzier chose supportive care, which cannot be considered a breach of the standard of care. My friends rely on the CPSO guidelines to establish the standard of care, and the CPSO has stated that the standard of care during a pandemic is for a doctor to practice in accordance with the Ministry of Health, CPSO, and hospital policies or procedures. Thus, with insufficient evidence supporting either ivermectin or MAF+, it would have been negligent for Dr. Letzier to abandon a treatment plan supported by hospital policy and multiple health organizations. We cannot deny that the death of Ms. Stark was a terrible tragedy, but Dr. Letzier had every reason to believe he was making the right choice in treating her. To conclude my submissions, we respectfully submit that Dr. Letzier did not breach the standard of care by choosing not to review the literature provided by Dr. Strange. Dr. Letzier had significant knowledge of the high and medium quality literature for the treatment of COVID-19 to provide Ms. Stark with the appropriate evidence-based care. Further, we respectfully submit that Dr. Letzier is not liable for medical negligence, as he chose to follow the hospital's COVID-19 treatment guidelines and use supportive care instead of potentially harmful treatment. Subject to any further questions, that concludes my submissions. My co-counsel will now address the remaining 2 issues.
Good morning, Justices. My name is Nicole Davidson, and I will be dealing with the final 2 issues on causation and vicarious liability. I have 2 points on my submission. First, Dr. Letzier did not cause or contribute to Ms. Stark's tragic passing. And second, the hospital cannot be found vicariously liable because Dr. Letzier met the standard of care. My first point sets out the applicable test for finding causation. I will also consider the facts of this case and the relevant medical literature to demonstrate why causation has not been proven on a balance of probabilities. Even if this court determines that Dr. Letzier breached the standard of care, we submit that he is not liable in negligence because the plaintiffs have failed to meet their burden of establishing a factual causal connection between Dr. Letzier's actions and Ms. Stark's death. Factual causation is established by applying the but-for test. The plaintiff must prove that the harm would not have occurred but for the negligence of the defendant. The plaintiff carries the burden of showing that it was more likely than not that adequate treatment would have prevented the outcome. It is not enough to show that adequate treatment would have afforded a chance of avoiding the outcome. unless this chance passes the threshold of more likely than not. This court bears the responsibility of determining whether the plaintiff has met his burden of proving causation on a balance of probabilities. We maintain that our friends are unable to prove on a balance of probability that but for Dr. Lutsier withholding Math Plus or ivermectin, Ms. Stark would have survived. Even if Dr. Lutsier had read the studies provided by Dr. Strange, it is unlikely that it would have changed his course of treatment. When Ms. Stark was admitted to the hospital, she was experiencing what are classified as moderate to severe COVID-19 symptoms with severe shortness of breath and mild hypoxia. Now, the studies provided by Dr. Strange are inconclusive regarding ivermectin's efficacy in treating moderate to severe COVID-19. The National Institute of Health has considered the randomized controlled trials on ivermectin and has identified key limitations for each. These studies are insufficient and do not speak to the efficacy of treating severe COVID-19 with ivermectin. Justices, I'd like to turn your attention to our friend's factum, starting at page 12 and paragraph 41. Our friends rely on various studies regarding the use of ivermectin to treat COVID in an attempt to prove that Dr. Lutsier caused Ms. Stark's death by withholding this treatment. However, we respectfully maintain that these studies are insufficient to render such a conclusion. The studies provided have various limitations, including studies of ivermectin's use in the prophylaxis stage, a study that is not yet peer-reviewed, and studies that concede that the efficacy of using ivermectin for COVID is inconclusive. The studies they rely upon have a common theme. They agree that evidence is limited and that more research is required to confirm whether this is an effective treatment for COVID. Further, the National Institute of Health confirms that using remdesivir in conjunction with dexamethasone is the appropriate treatment for moderate to severe COVID. Health Canada has also authorized remdesivir for this purpose. Now, we also submit that the correlation between Ms. Stark's condition improving and treatment with ivermectin and Math Plus is not enough to establish causation. Twice in the course of her stay at the hospital, physicians stopped the standard treatment plan and provided either ivermectin or Math Plus to treat Ms. Stark. Our friends draw correlation between Ms. Stark's condition improving and these treatments. However, as the facts show, ivermectin was administered to Ms. Stark on day 6 after onset of COVID. Her symptoms did temporarily improve, but the next day she was placed on a mechanical ventilator for the first time since being admitted to hospital. Her condition improved again after receiving Math Plus around days 9 to 10, but then she deteriorated around day 12 and was placed on a mechanical ventilator. The Math
Counsel,
Plus
don't the deteriorations coincide with your client removing the Math Plus and ivermectin treatments?
Thank you, Justice McGuire. Yes, you're correct. Her symptoms improving and then ultimately deteriorating do coincide. There is a correlation between the treatment of Math Plus and ivermectin and her improving. However, we maintain that this is not enough to establish causation. We're saying it is merely possible that Math Plus and ivermectin temporarily improved her condition. However, it's also possible that deviating from the standard treatment plan and intervention with a new treatment could have resulted in further complications. And I do rely on this from the FLCCC Math Plus protocol information that Dr. Strange provided that says Math Plus should be administered hours after the patient requires oxygen supplementation. In Ms. Stark's case, on October 5th, when she was admitted to hospital, she required a nasal cannula for oxygen. So as the literature provides, late intervention with Math Plus can lead to complications, such as the requirement for mechanical ventilation. So our position is that it's possible that these treatments temporarily improved her condition, but it's also possible that deviating from the standard care complicated things further. As of October 19th, 2021, Health Canada warned health professionals against using ivermectin to treat COVID-19, explaining that Health Canada has not yet received an application for clinical trials for ivermectin to treat COVID. Additionally, in Dr. Strange's deposition, she concedes that the CPSO issued a warning to her to stop administering ivermectin to treat COVID. The facts before you are clear. The regulatory body for physicians and federal health agencies do not recommend treating COVID with ivermectin or Math Plus due to the lack of evidence and the inherent risks. Now, to answer Justice McGuire's earlier question to our friends, it is also possible that Ms. Stark's deterioration was due to the virus alone. The CDC warns that some COVID-19 patients will rapidly deteriorate about a week after onset of illness. Furthermore, other sources indicate that the patient may start to feel better around day 7 to 8 of illness, but then some symptoms can worsen. This lines up with Ms. Stark's condition. She was moved to the ICU on day 5, and on day 7, her symptoms worsened and she was intubated and placed on a ventilator. The plaintiffs have presented theories about the efficacy of Math Plus and ivermectin that are not backed by government health agencies such as the FDA, CDC, or Health Canada, who all recommend treating COVID with remdesivir and recommend against the use of ivermectin. Both sides accept without a doubt that complications resulting from COVID-19 caused Ms. Stark's death. Unfortunately, Ms. Stark entered the pulmonary phase of COVID-19 during her stay at the hospital and developed advanced lung disease as a result, which is the leading cause of death in COVID-19 patients. The question is whether by withholding ivermectin or Math Plus, did Dr. Lutzier contribute to Ms. Stark's death? However, the evidence before us does simply not point to this conclusion conclusively. Nothing in the evidence before us indicates that it is more likely than not that ivermectin and Math Plus are effective against severe COVID-19, which Ms. Stark was battling. Furthermore, COVID-19 is a novel virus and we are still learning so much about it. What we have learned about COVID is that it does not discriminate when it comes to who gets sick or how sick they get.
For counsel, though, as I understand your friend's submissions, isn't their point that it wasn't that he necessarily should have given that medication or treatment protocols, that he should have collaborated with Dr. Strange and read the studies, and if he decided that he didn't want to treat her, should have transferred her care? Isn't that really the basis of their standard of care submission? I mean, what do you say to that?
Thank you for your question. So in terms of speaking to the failure to transfer the patient and proving causation on that basis, proving causation relies on the belief that if Ms. Stark had been transferred to Dr. Strange earlier, it is more likely than not that she would have survived. However, we know that Dr. Strange would have treated Ms. Stark with ivermectin or Math Plus protocol. And as I've discussed, the evidence before us simply is not conclusive regarding whether these treatments are effective for COVID at all, let alone for severe to critical COVID, which Ms. Stark was suffering. To conclude my first point, the plaintiff has failed to meet the burden of proving causation, and therefore Dr. Lutzier cannot be found liable in medical negligence. Moving to my final point, West Valley Memorial Hospital is not liable for Dr. Lutzier's actions because Dr. Lutzier met the standard of care and did not cause or contribute to Ms. Stark's harm, and thus is not liable in negligence. The hospital may only be found vicariously liable if a salaried physician is negligent in their care of the hospital's patient. There is no liability without negligence. However, if this court does find that Dr. Lutzier failing to review the literature is a breach of the standard of care, there are strong policy reasons to not hold the hospital vicariously liable. In Baisley and Curry, the Supreme Court states that vicarious liability is appropriate when there is a significant connection between a risk created by the employer and a resulting wrong committed by the defendant. I wish to point out that in Dr. Lutzier's employment agreement, the hospital states that the physician shall render services in a competent, professional, and ethical manner in accordance with the current and prevailing medical standards. Furthermore, this hospital fosters an environment of ongoing learning by having an interdisciplinary team review the new literature of COVID-19 monthly and amend their treatment protocol on that basis. The hospital did not create a risk that new literature would not be considered. They actually advance this goal through their actions and their employment agreements.
Didn't it potentially create a risk, though, by imposing a hospital policy that it required its physicians to follow, where that policy may very well not have accommodated other options and newly evolving literature?
Thank you, Justice. To answer your question, in a case such as COVID, where the literature is rapidly coming out, at this point in the COVID-19 pandemic, the approved treatments that had enough studies available were very limited. And so it was natural that the hospital would have a protocol to ensure that the most up-to-date literature was being relied upon. Now, this might be a different story if this was a case of, for example, another treatment where there's two approved treatments that have equal weight. If they had a policy saying only one of them was appropriate, in that case, that would create a risk. However, in this case, this was not actually creating a risk. This was actually trying to prevent risks of new experimental treatments being used in lieu of what's proven to be most effective.
Councillor, did the hospital not have a duty to act, though, when the therapeutic relationship had broken down between the physician and the family in protecting the patient's best interests?
Sorry, do you mind repeating your question?
Did the hospital not have a duty to act where the therapeutic relationship had essentially broken down between the patient, between the physician and the family, when he was refusing to collaborate with the family in effecting a transfer of care to a team that would be able to accommodate the family's wishes?
Thank you for your question. In this case, we are only considering the hospital's liability as it relates to the care that Dr. Lutsier provided. So we maintain that Dr. Lutsier's decision not to transfer the patient sooner was his call because he was the most responsible physician that was responsible for Ms. Stark's care at that time. We are only considering the hospital's liability with respect to his actions. And so in this case, we do not believe that the hospital had a duty to intervene and have the patient transferred. Thank you. Now I'm mindful of my time, so I'd like to conclude my submissions. We respectfully ask this court not find against Dr. Lutsier for negligence. In times of a global pandemic, the court should not set a precedent that encourages doctors to deviate from the standard of care set out by federal health agencies and instead deploy experimental treatments. This would put the patients at a greater risk, and the public would lose confidence in the healthcare system. Doctors should not fear liability and negligence for following the accepted standard of care. Dr. Lutsier did not breach the standard of care, nor did he cause or contribute to Ms. Stark's untimely death. As a result, this court should not find Dr. Lutsier nor the hospital liable for damages owed to the plaintiff, and we seek the award of costs as a result and such further and other relief as this court deems just. Subject to any further questions, that concludes my submissions.
The court now invites counsel for the plaintiff to begin their optional 3-minute rebuttal.
Thank you, Justices. I'll be brief. The defendants have raised a policy concern regarding the standard of care argument that potentially physicians will now be afraid of adhering to customary practices, given that if negligence is found in this case. We just want to point your justice's attention to the particularities of this case. The plaintiff is not suggesting that merely adhering to supportive care is the issue here. It's that the surrounding circumstances, the issues regarding collaboration, all of these in conjunction are what gave rise to the negligence. So we would submit that this would not lead to essentially a floodgate of litigation for all physicians that merely adhere to supportive care. It's a very particular case. Thank you.
This concludes the matter of Stark and Lutsier.